Good morning. Welcome to the West Metro Alliance Program on the Federal Judiciary Study. I am Sue DeSalle, a member of the Lake Minnetonka Plymouth Area League and a retired Minnesota State Court Administrator. Also, your moderator for this morning. Please excuse my wearing glasses today, but I have an eye issue that requires it, so my apologies. This meeting is being held to prepare us to participate in the LWVUS study of the federal judiciary, and specifically to provide important background information on several areas of interest identified by the National Committee. The plan for this next 90 minutes is that I will start by introducing our speakers, then provide some background for our first topic, followed by a Q&A session with the speakers. We'll use that same process for the additional 4 topic areas that will be covered this morning. And time is reserved at the end for your questions, so please type them in the Q&A box. So to give us some great information about how the federal judiciary operates in these areas of interest, I am so honored to welcome our 2 speakers. First, the Honorable Donavan Frank. Good morning, Donavan.
Good morning.
Judge Frank was born in Rochester, attended Luther College and Hamline University Law School, graduating magna cum laude from both. He began his career as an assistant county attorney in St. Louis County, and in 1985 was appointed a state district judge in Minnesota's 6th Judicial District. In 1998, Judge Frank was nominated by the President and confirmed by the Senate as the 31st United States District Judge for the District of Minnesota. After 18 years, in 2016, Judge Frank assumed senior status, but by no means has he retired, as he continues to carry a very full caseload. We are also so fortunate to have with us today Manny Atwal. Good morning, Manny. Manny is the first assistant federal defender for the District of Minnesota. She is a 1994 graduate of Oregon State University and a 1998 graduate of William Mitchell College of Law. While in law school, Manny clerked at the Ramsey County Public Defender's Office, and upon graduation began her career as an assistant public defender. In 2001, Manny joined the Office of the Federal Defender. And in addition to her great career with that office, Manny has been an adjunct professor at 3 of our local law schools and speaks nationally and locally for both the public and private bar. So thank you both for being with us this morning. So let's start with the first area of interest, judicial ethics, and a few words by way of background. As you know, the framers of our Constitution were intent on assuring the independence of American judges. So Article 3 of our Constitution provides that federal judges will be appointed, not elected, which frees judges from having to run for election, raise money, or take into account what's popular in order to get reelected. Article 3 also gives them lifetime appointments and guarantees that their salaries can't be diminished during their tenure, further freeing them from dominance by the other branches. The only check provided is the extraordinary step of impeachment. And since judges can't be fired, demoted, or their salaries cut, the area of lead concern is how does the federal system respond to ethical issues that arise? Now, there are 3 sets of rules that govern judicial ethics and enforcement in the federal courts. The first is the Code of Conduct for United States judges, which applies to the U.S. District and Circuit Court judges, the lower courts. A separate statute, the Judicial Conduct and Disability Act of 1980, provides a complaint and disciplinary framework, including sanctions for the district and circuit court judges. The third is the Voluntary Justices Code of Conduct, which applies to justices of the Supreme Court without an enforcement mechanism. So to start us out, Judge Frank, based on your long experience in both state and federal courts, could you just give us an insider's perspective on how judges think about their ethical responsibilities?
Yes, I can. And before I do that, just want to take just 30 seconds and thank the League not only for doing these things, but I've met so many people at the league because they're one of our biggest participants in our naturalization ceremonies, and we so appreciate their work. Now, in some ways, if we are in the same room, so I could look at you as one human being to another, so you know that I sincerely believe and mean what I'm about to say. The judges I've always worked with, yes, we all make mistakes, but you know, everybody, the hundreds I've worked with, we take our oath so very seriously. And you had that photo up there. In other words, we promise to follow the Constitution and the laws, and to and keep politics out of everything we do. That is the promise and the oath that we take. And every judge, because every judge I've worked with in my career and the ones I'm working with now, uh, because we understand what a true privilege it is to serve as judges and have the guiding principles of interest of justice and respect for the system, and the rule of law. We take that oath very, very seriously. And so, and like I said before, and that is to keep all politics and other issues out of everything we do. And then one other comment is that that oath is so important for another reason. We are to behave in such a way to avoid even the appearance of impropriety or the lack of and that we're to partiality. So that that is one of the most important things for each of us, and that's our first responsibility as a judge. And
Could you give us an overview of the process for handling ethical complaints made against federal judges, district and circuit judges, and what are the possible consequences that if a federal judge violates the code of conduct? So we know that the vast majority of judges are certainly appreciate that oath and do everything they can, but occasionally there will be a stray. So could you tell us a little bit about how it?
yes, and there's a couple of different avenues. One is, and I won't touch on that one first, and that is a party can bring a motion to remove a judge for bias, whether that's based upon unethical behavior, other things, and or other things that they've done, either how they've behaved or something they've said in the courtroom or an opinion. But one of the other remedies, even apart from bringing a formal motion, that then and then that can be appealed to the circuit court when you're a federal judge. The there's an ethical responsibility. They can file a complaint with the chief judge of the circuit, and then the circuit judge, like in our case, they come and visit and hold cases in like Minnesota. The chief judge, his primary basis is in St. Louis, but they come and circulate. Then they can even put a committee together to evaluate the behavior and conduct of the judge. And so that's another remedy that can be done separate from a formal motion. And I'll just say this, we've seen an increase in the last 2 or 3 years, including right now, not by lawyers making the complaint, but we have the largest set of what we call pro se cases, where somebody either doesn't want a lawyer, and because if they want a lawyer and can't afford one will be appointed for them, whether it's criminal or civil. But we've seen an increase by those, basically, if they don't agree with your decision, or they kind of look at your background and apart from your decision. But so the two main avenues, the big one is to go to the chief judge of the circuit court, and then they can, with or without a committee, do an investigation. And then I think part of your question too is if they do find a violation, they can remove you from the case. They can't suspend your salary. They can though take you off a particular type of wheel. Like, let's say, for example, there's an assignment we'll talk more about later, say employment discrimination, for example. They can say, okay, we're going to suspend you from that either permanently or for X number of months, or they can suspend you entirely on a case because there may be some other issues about your behavior. And so, but those are the remedies that each party, every party, represented or not, has, whether it's civil or criminal.
And as I understand, Judge, it can actually request a judge to retire or certify a disability. So
And
there's
and actually, right. I'm sorry to interrupt. Yes, in fact, there actually has been, whether it was requested or not, a judge just recently retired, I think, and another, not in our circuit, but there may be different reasons for that. And then we may talk about later a number of districts, like our district, we have a policy where if there's an issue, whether it's a disability or behavior issue in or out of the courtroom, then usually a judge is assigned to with the chief judge to talk to that judge and to look at remedies or to remove them from calendars or hearing cases. And sometimes those things are public. Oftentimes they're confidential too, depending on the nature of the case, because that we have policies in our district for that as well, whether it relates to behavior or a disability or some other issue.
So Manny, we just talked about the kind of disciplinary process that is available for a violation for the lower courts. And there's a broad range of sanctions that are available for that. But what about the Supreme Court? What is the rationale that the Supreme Court has just a voluntary code of conduct without an enforcement mechanism? So, if a complaint were filed against a justice of the Supreme Court, how would that be handled? And in your view, do you think there should be an enforcement mechanism for the Supreme Court? If you wish to answer that.
So let me start by saying I'm going to be speaking on behalf of Manny Atwal, not on behalf of the Federal Defender's Office. So my views that I express here are not the views of my office necessarily. It is going to be my views. And before I get to the Supreme Court, I do want to just touch really quick on something Judge Frank said about filing complaints against judges on the district court level. And I think it's very different if you're in the criminal justice system and you want to file a complaint, whether you're the government or you're the public defender's office, because it can be very difficult because this is the same set of judges we're always appearing in front of. That's not going to change. And if you file a complaint, it can be a very uncomfortable feeling for you, right? Because you file a complaint against this judge, this is the same judge you may have on other cases that come up. And I'm not saying it happens in this district, but I've heard it's happened in a lot of other districts because I think our district court judges are wonderful. Whenever I've had an issue, I don't think it really, with a judge, I don't think it ever really goes to the level of an ethical complaint. But I am fortunate that I have people like Judge Frank that I can turn to and say, I'm having this issue with the judge. I don't know what to do. Can you help me out? And I know Judge Frank will always keep it confidential and figure out a way to get to that other judge and resolve the issue. But I do think sometimes it's very difficult for those in public service appearing in front of a federal judge to file a complaint just because of the ramifications that could happen down the road. Okay, now that being said, let's go to the voluntary code of conduct by the Supreme Court justices. So these aren't really rules, right? They're a set of principles that all 9 justices signed off on November 2023, I believe it was, saying that we agree that this is the rules that we're going to follow. And so there's no enforcement mechanism, right? There's nobody policing them, nobody saying, did you do this? Did you do that? Have you disclosed this gift? Have you disclosed this travel? Have you disclosed this conflict? But they are saying, look, by us signing this, we are promising this is what we're going to follow. So the question becomes, if they're signing off on it and there's no enforcement, like Judge Frank said, there's enforcement for the district court level, what's the point? Well, the point is that they signed it, and we've got to be able to trust our 9 Supreme Court justices that they're going to follow it. So me personally, do I think there should be an enforcement of it? No, I want to believe that our justices are going to do the right thing. And that's not me being naive or thinking that, everything's lovely, there's sunshine every single day, and of course they're going to follow things. But what my concern is, what we're seeing today, politicized the courts, right? We're hearing this judge should be impeached because they're not following what my political party wants. So the real issue is if you have enforcement and you have that enforcement coming from Congress, where is the separation of powers? Where is judicial independence? It's not there. So I say no enforcement. I want to be able to trust the 9 Supreme Court justices that they will follow the code of conduct and leave out the policing by Congress, because I just think it becomes a slippery slope. We're already seeing some of that happen right now. And I would hate to think that one of our justices, even though it's 6-3 right now, 6-3 conservative, 3 liberal judges, that influence can affect their decision making, because I want to believe that they are impartial when a case comes before them and they hear argument and they don't have those outside political influences. And if you stop policing them, I think that separation of powers is no longer there.
Manny, just ask you to follow on that. If Congress was not specifying the enforcement mechanism or the sanctions, but instead asked the Judicial Conference, which is the policymaking body for the federal courts, to create one for itself, would that have any mitigating factors in terms of your view of this particular question?
Perhaps. I mean, we saw them kind of, when a complaint was filed with Justice Thomas, right? And his was more about financial, about taking vacations and getting them paid for. And you saw that there was a complaint filed, and then it was investigated, but nothing's really happened with that investigation. So it hasn't gone any forward to the Attorney General. It's kind of just been stuck there. But again, I just think having them sign it does mean something. It does mean they're acknowledging what they need to do. So I just say, just kind of leave it be. I think the Supreme Court is different. It is special. They still should abide by the rules or the principles, so to say, but I think they can do it themselves.
Well, thank you. Well, let's move on to our second.
I have one other thing, Sue, if I may.
Sure.
And that is, before we move on to the financial disclosure issue, I think there are some questions sometimes about, well, what about the ADA? And then are any of these things public and private? And the answer is most are not public, some are. But like, for example, in some districts, including our district, when a new federal judge comes on, they're saying, in addition to the chief judge of your district, which is different than the chief judge of the circuit court, if there's a concern about your behavior or disability or any issue, what family member or colleague do you want to address you along with the chief judge? Well, I've had to do that on a couple of occasions, and in fact, in one case was, well, if somebody doesn't address this, the lawyers may be filing a motion because of some mental health, some maybe other mental health and memory issues. And so I think there's ways to do that can be respectful of everybody without compromising the interest of justice or anybody's oath. And so those things can happen. And like I say, some of them become public, many of them, just like for lawyers, actually, most lawyers, unless there's a public reprimand, most of those things, unless somebody is suspended or revoked. But then, of course, it'd be public if someone is temporarily off the calendar for X number of months or permanently, or if they're but those are issues. And in fairness, I think to the public and everybody, I mean, I think the system is much more sensitive to a lot of those issues now than maybe decades ago. And to keep that respect and independence for the rule of law and the judiciary.
Great. Well, thank you. Okay, let's go to financial disclosure, which is the second area of our concern. And by way of background, the Ethics in Government Act and the Stock Act require many high-level government officials and employees in all three branches to publicly disclose all manner of financial information and investment transactions. One exception is something called the personal hospitality, which doesn't require reporting food, lodging, or entertainment type gifts received as a non-business personal hospitality. Because of some controversy recently in 2023, that personal hospitality term was narrowed to specifically exclude gifts such as transportation by a private plane from requiring that those gifts now be reported. Unlike the other two branches and the federal district and circuit courts, the Supreme Court takes the position that it complies with the statutory disclosure requirements as a matter of internal practice and has no specific enforcement mechanism. So the lack of enforcement is the basis for this area of interest as well. Okay, Judge Frank, could you give us some sense for the comprehensiveness of this financial disclosure requirements and how frequently federal judges and justices report that?
And I think this will, if many of our viewers are not aware of this, I know many people in the public are not aware of this, this may very pleasantly surprise you, as it did me. And now you're thinking, what is he talking about? Well, when I went from the state court as a state judge, I was a state judge for 14 years. I came to the federal court because there wasn't such requirement in the state courts. I was stunned to see, and this isn't critical of it, a highly mandated manual or annual requirement that anything you own, any interest you have, whether it's 1 penny in the bank, 1 penny in stock, a gift of any kind, it all has to be disclosed, and those forms are all public and accessible. And you do this on an annual basis, and I mean you have to disclose everything, and there's very strict rules. That's why I had probably messaged you before when I spoke at a seminar not too long ago, and they tried to give me a check. I said, we can't take 1 penny from anyone, and not because you and if you do, like for example, so whether it's the home you own, and it also applies to your family as well, spouse, a child living with you, anything, any interest, any control you have, it all has to be disclosed. And then a committee with the judicial conference screens it very carefully and strictly once a year, because if they feel you haven't filled everything out completely, you get an email saying you have to update this because this wasn't filled out. So that's done on an annual basis. And then something that'll probably come up later, the reason there's fewer recusals and other conflicts, they program that financial disclosure into our random assignment. We'll talk more about how judges can't pick a case or not take a case. It's all randomly assigned. They computerize and put your financial, any issues into the random assignment. So then you can never be assigned a case, whether you have 1 penny stock or this or that or that. And so that's all programmed into the assignment process for cases, which we'll talk about more. But so no, most of us don't complain about it, but it's a very strict but fair system. That transparency issue, get it all out. But I have to confess, I was surprised when I went on the federal bench. Wow, I have to fill out every detail of every single thing I have, and so what I think does kind of promote that kind of respect for the. I'll stop talking now because you might have other questions for me and want to ask Manny a question. But yeah, that's required of all federal judges, all circuit court judges, and so
And
it's
the
yes.
Supreme Court as well.
Yes, correct.
Well, Manny,
go ahead.
if you have some, go ahead.
No.
Manny, again, with respect to financial disclosure, You know, what is the rationale that accepts the Supreme Court from the requirements of an enforcement mechanism that applies to these lower courts and the other branches?
So like I previously said, the rationale is judicial independence, that the Supreme Court should be able to govern itself and that the public should trust them that they're going to do the same thing. But of course, then we saw what happened, as I mentioned earlier, with Justice Thomas. And so two complaints were made to the Judicial Conference saying, hey, wait a minute, Justice Thomas is getting this travel. He's been hosted by these friends. We don't know what effect that has on his ability to be fair and impartial when he is presiding over cases. So a complaint was filed and the Judicial Conference began an investigation, reviewing the allegations, I should say. And what their job is to do is to say, is there reason to believe that Justice Thomas violated ethics? And if the answer is yes, so they're not even investigating. If the answer to that question is yes, then they can refer over to the Attorney General. Another way it can happen is if there's a complaint filed, Chief Justice Roberts himself can say, okay, I do think there is an issue and can refer the case on. How often does that happen? When does that happen? Well, obviously, we've seen that nothing's really happened with Justice Thomas. And from my research, because eventually somebody can be impeached and removed from the Supreme Court. It's only happened one time where somebody has been impeached. So the House of Representatives can say impeachment, and then the Senate can say conviction, and then the Supreme Court justice could be removed. So the big argument in saying that it should be monitored is for public trust, right? For the public to be able to say, okay, we do need some type of enforcement. We do think you should be held to the same ethical standards as Judge Frank and his colleagues on the district court bench. So that's the argument for it. But again, I go back to, for me, it comes down to separation of powers. And I just think, again, I don't want to see the Supreme Court be politicalized as much as it already has right now in this environment that we live in. And so I think for me, as I previously mentioned, voluntary compliance is the way I think it should be. But again, that's just my opinion. I know there's a lot of like very, very smart legal scholars that say, no, we should police it. And the main argument is the public trust. And I completely understand that.
Well, I think it's interesting that I don't know that most people would know that there was an investigation of this, but it certainly was the public visibility, hearing about it, I'm sure. And as a result, I believe that led to the change in this personal hospitality to clarify. So as I remember, Justice Clarence Thomas indicated he thought that he had discussed it with other people and he thought that was within the realm of that personal hospitality that didn't require reporting. So now they've clarified it, so they've taken steps to do so. The issue for the league is still, you know, why should the Supreme Court be different than the others? Well, thank you. Thank you very much. And Judge Frank, you got something?
Another thing that we touched on a little bit before, and doesn't relate to the additional opinions about the Supreme Court, but and I know there's a lot of people, given the times we live in and maybe prior to now, say, well, do the people really, the judges really follow that oath and believe it? But the other thing is, apart from the strict financial disclosure rules, actually it goes one step further, because as I touched on a little bit before, and again, I could look anybody sincerely straight in the face, and I know that my colleagues and the people I've met and judges across the country feel as I do. We have a responsibility to avoid behaving in such a way to avoid even the appearance of impropriety. And so the whole issue about, well, this rule, well, it goes further than the rules. We are not to do anything that even creates the appearance of impropriety. And so that really is an important consideration for our behavior in and out of the courtroom and handling decisions. And it relates also to some other issues, directly, indirectly, like recusal and issues like that. But I mean, that really, whether the average person on the street believes us or not, and I think frankly, and you can put this question to Manny. I think the majority of lawyers, with some exceptions, would say, you know, we think that judges, state and federal, take these rules seriously, including that really broad, the avoiding even the appearance of impropriety, because that's such a crucial issue to maintaining the respect and independence of the judiciary and respect for the rule of law. And so I really think that that's something that is discussed a lot by judges and other people. Well, it may or may not technically violate that rule, but it goes further than that. We must avoid even the appearance of impropriety, and because it's going to cause disrespect and for the court system.
Yeah.
And Sue, can I just want to touch on that. And I want all of you to know, I'm not saying this because Judge Frank is here and I appear in front of him. I 100% believe this. Our district is, I sometimes feel it's very different from other districts because Senator Klobuchar and the senators before her have really done an amazing job with our district court bench, right? Like, no matter if it's been a conservative president, a Democratic president, it doesn't matter. We really have amazing judges. And they will, if they think they have a conflict, they will absolutely say, hey, I'm not going to take this case. And again, we'll go on to this a little bit more in the public trust section, but what Judge Frank is saying is really true. Like, if they think they have a conflict, and there's so many different ways that a conflict can be created. In my 24 years that I've been at the Federal Defenders, I am absolutely always like love it that judges will say, I'm not going to take this case, and a new judge assigned. And that is the way it should be. And I think that's a really good thing.
Well, great. We are moving on to that next area, which is recusals, as our third topic. So recusals occur when the assigned judge takes him or herself off the case because the judge believes he or she has a possible conflict of interest or may lack impartiality. Both judicial codes and the statutory provisions require judges to recuse where their impartiality might reasonably be questioned, including when the judge has personal knowledge of the facts of the case, has some financial interest, or past involvement in the matter. So how this is handled is an area of concern for accountability and transparency, given the lifetime status of federal judges. So Judge, could you please give us an example or two as to why a judge would recuse? And I think you mentioned this before, but they're related to the court's automated conflict screening software. And what kind of impact has that had on the need for recusals?
Yeah, I'll first touch on that, and then I'll go give you actually a couple of examples where I've recused, and we can also talk about the issue of disqualification and and public versus private and all the issue. But the with that software and that financial disclosure form, they program that into the assignment system. So first of all, some of you may be surprised if you haven't heard this, because this wasn't all up until a number of decades ago. There wasn't a random assignment system of cases. So a judge could say, I want that case, or I don't want that case. Well, we're not supposed to be advocates, except for the interest of justice. We're supposed to take the case, and so the random assignment system, now it's all random. A judge can't say, unless he or she recuses, they can't say I want that case or I don't want that case. Not permitted. And so the random assignment system has really especially when you program into that your any interest you have, in other words, whether it's in a company, in a bank where you have accounts, any relationship, that's all built, and then that's all programmed into the assignment system. In fact, then what I didn't mention before on the financial disclosure form, and once a year that same committee reviews the conflict of interest form that you have to fill out every year too. That's part of that is related to the financial form, but it could be non-financial issues, and they'll look at that to say, well, are there any changes to be made on any conflict? Because then they program that into the random assignment plan too. And so I think that's reduced some of the recusals or the motions to disqualify, and we'll talk about that too. But that random assignment thing, it also reduces some of the allegations of, not that there's not allegations of bias and so forth, but it also reduces that because it's randomized where a judge can't say yes or no to a case, because that wasn't always the way it was around the country. And so then moving on to recusals, I can give you and most of these, with some exceptions, until motions are filed or appeals and declining to recuse or disqualify yourself, are private, but that could be for a couple of reasons. For example, I recused in a case in the last couple of years because one of the medical people, you'd think that with 5 daughters, I'd have a lawyer in the group, and some of them should have been lawyers instead of doctors, because I've never won an argument with them. But I got a call from a lawyer, but I said, well, you're one day too late. My daughter, she somehow found out on a case that somebody she went to med school with is part of this lawsuit. So I said, this at a minimum, didn't ever know her, but to avoid even the appearance of impropriety, I'm gonna recuse. Then I had another case that was either for or against the Mayo Clinic, and until a few years ago, I had a sister who had a very significant role at Mayo. I recused there. And then there are some cases where if a case you had a family member who's been a victim in a situation or in a similar situation, you're not going to kind of tell the world, but either it's, even if it doesn't create the appearance of impropriety, if nobody knows about it, you have an oath of office to do that. And then usually you're not required to give a reason publicly, but with few exceptions, if there's lawyers on the case, you will oftentimes let them know, well, here, I'm recusing, and just so you know, I'm just not trying to avoid your case. Here's why. And so you know that it wasn't a concern about one of the lawyers or something else. And so that's, but then in the event that you are, or let's say that a pro se party or a lawyer, you haven't recused, or you decline to, or sometimes they use the word disqualify, then they can file a motion to disqualify you. Then if you say no to that, they can appeal that. They can appeal that to the circuit court and say, whether it's because he's biased or he has an interest to that. But the majority of recusals generally then will be private and no reason given, but often publicly, but oftentimes the lawyers, and I suspect then that the parties, the lawyers in a number of cases, unless the judge, if it's been something very, very confidential or private, will probably tell their clients, well, the judge, and then there's a new random assignment then to the case. So, but I think that's crucial that we all take seriously. But just to give you and I don't think my situation is any different than most of my colleagues. I'm in my 26th year as a judge. I've recused 3 times in 26 years. However, you have to build into that conflict software and financial disclosure form that's programmed in to the random assignment plan, so that those are cases that you're never going to be assigned at all. And so that's programmed into that. So that has significantly reduced the recusals. And usually the motions to disqualify are often alleged they're probably frankly alleged more on bias than they are about conflict of interest or anything else, so.
Judge, could I just follow up with that about the recusal decision and the concept that might be proposed that these recusal decisions should be the reasons for them should be publicly disclosed. Why would that across the board requiring a written statement of why you're disclosing be perhaps unwise?
Well, because a lot of times, because number one, first of all, a lot of the conflict issues and everything have already been programmed into the assignment, into the software, so you can't get, so it's rarely, if ever, going to be for that reason. And then, for another example, I'm not going to name the judge and say whether it was in my district or not, but someone who was getting sex trafficking cases, their daughter had been a victim of a rape at a, and so we're going to make that public. And actually, in that case, to be candid, the judge did contact the lawyers in that case, said, and I think the reason I knew about it was because I had the largest sex trafficking case in America here. It's about done now with all these young girls, women coming from Thailand. But but I think a lot of these things are very, very confidential and personal. Whether the judges told the lawyers or not, and so because most of the conflict issues have already been programmed into it, so the judge wasn't going to get assigned. But I understand the concern some people have. Oh, this judge recused. Well, in the majority of those cases, based upon my experience and working with my colleagues, just not here but elsewhere, in the majority of those, the judge has let the lawyers know, because whether it's privacy for another individual or confidentiality for another individual, that the judge wanted that you do it just to make sure that you avoid even the appearance of impropriety. And so I don't know if you can feel free to ask me any other questions, and there might be, and again, depending on the circumstances, if somebody has that strong a feeling, they can, I've actually never had that happen or know of a case where they've said, well, we're going to bring a motion to declare publicly, because that would probably have to be an interest group, because in most cases, the lawyers are going to know. They've been told, but in some of the cases, it would be very, very private, and especially with the strict conflict rules, that's already been kind of removed from the system. So and Manny or
So
maybe,
can
Manny, do you have?
sorry.
Yeah, I wanted to say, I do think it's really important that when it is a conflict, and particularly again with criminal cases, and the judge has a conflict, I don't want it to be public, because I want that judge to say, I cannot be fair and impartial, so I'm going to disqualify myself. My fear is if we make the judge make that public, maybe that judge is trying to protect their husband or their wife or their child, like the judge was saying, or even themselves, right? Like they've been a victim of, let's say, a robbery. And so they can't be fair on the robbery case that's coming up because it's going to bring back memories that are not good, and they cannot be fair and partial to my client. But if they have to disclose that publicly, perhaps the instinct as well, I'll just try and be fair and impartial, so that way you don't have to disclose that my husband was a victim just 2 weeks ago, and so I'm just going to kind of power through this. I don't want that to be the case. And I know that's going to kind of bring us up to the Supreme Court and their duty to sit, but I rather it be the way that it is right now. And I will say again, maybe I'm just fortunate to be in this district that if a judge, I feel like the judges I appear in front of that have they don't think they can be fair and impartial on a criminal case because of something personal, that they do disqualify themselves. And I would say usually the judge will tell the parties, but even if they don't, I'm okay with that, because do I really need to know what it was that they don't feel that they are qualified to sit on the case and pass judgment on my client, I'm okay with that. If they're telling me they can't sit on it, I'm okay with that.
Now, there's one thing, not to interrupt you, Sue, and then, but it's probably beyond the scope of this. There's a very, very small number of recusals. And I've never felt I was in this position where a case you've decided unrelated to recusals or bias or anything, gets, you have a case appealed to the 8th Circuit, and then they reverse the case saying, no, on this issue, the judge erred, or we're sending it back on that issue. Well, then I've seen a couple cases where a judge has said, well, to maximize fairness to the party, since they said I was wrong, but I decided and I already said how I see the case, I'm going to recuse to match so that nobody has a concern that, well, the judge is just going to try to find another way to rule the same way. And so, and some judges have that philosophy. Well, if they get reversed, depending on it's a pure fact issue, well, what you just decided that on the same issue. Now you're going to try to do it a different. And sometimes to maximize the appearance of impartiality and fairness, they'll recuse even after they've had the case for a long time when it comes back from the circuit. But that's a relatively very small number of cases, because most of us, depending on the basis for reversal, will keep the case, and just because we take an oath then to follow. In fact, I've had cases where I've said, well, here's my decision. Now it's based upon this because it's consistent with the decision of the U.S. Supreme Court or the Circuit Court. So,
Great. Okay, well, Manny, now we want to talk a little bit about the Supreme Court here. It's different than the others, but tell us about how the Supreme Court, as the highest court in the system, has some unique considerations, and that is something that has come to be known, the duty to sit. Can you tell us a little bit about that circumstance?
Yes. So as Judge Frank was saying, the lower courts, the judge shall disqualify themselves if they cannot be impartial, right? And it could be financial, it could be personal knowledge about the case, it could be the victim of the case, it could be that they were an attorney at the firm that's appearing in front of them. Reasons why they would disqualify themselves, that they shall disqualify themselves. The Supreme Court justices have a different standard. They are presumed to be impartial, and they have an obligation or a duty to sit, meaning they will hear the case unless they are disqualified. But the rule of necessity steps in. So it says, okay, you have a duty to sit, you're presumed to be impartial, but if you think that maybe you're disqualified, but you're needed on the court, meaning the rule of necessity, meaning no other judge is available to decide, then you have to participate in the court. Okay. So what that means is they basically have to sit, even if they may be disqualified, if it's necessary for them to sit. Now, I was thinking about this, like how, like, is this a good thing, bad thing? And I was wondering how my opinion would have been different maybe a while ago, before the 6-3 breakdown with 6 conservative judges and 3 judges that were appointed by Democratic presidents. And I'm not sure if my opinion would change on this, because I see it as if one of those 3 justices that were appointed by President Obama and President Biden, if one of them said, hey, I may be disqualified for this, but out of the rule of necessity, I'm going to sit. I think I'm okay with that right now, because think about all the big political decisions that are being made right now. And by political, I mean, whether it's abortion, whether it's gay rights, whether it's women's rights, whether it's rights that affect every single one of us. Right now, if one of those 3 were not sitting, I don't know how the court's going to rule. So maybe the duty to sit, and i.e. kicking in the rule of necessity, is good right now. But I'm not sure how I would feel if it was a 4-4, right? I kind of went back and forth in my head about how I feel about this. But right now, as it is right now, there is a duty to sit out of the rule of necessity. And the biggest reason why the advocates are saying this is why it's got to be is because, again, we're trying to stop the courts from being politicalized. But if one of those justices is missing, how does that change the outcome of what the Supreme Court is going to rule? How is it going to change? So that's the biggest advocacy reason why there is that duty to sit, is out of the rule of necessity.
But unlike the lower courts where there are multiple judges, if one judge recuses, there is somebody else available to put into that case. And so
Right.
the question is, that's not the situation for the Supreme Court. They have what they have. There aren't going to be substitutes for that. If you have a even 4-4 split, what they say is that advantages the plaintiff, the one that's bringing this appeal to the Supreme Court, because that will necessarily affirm their position, which was the position in the lower court. So it has all these complications that make it more difficult to say, well, the Supreme Court should be just like all the others, because it may not be. And that's an interesting.
Yeah, and this particular subject matter is why there's advocates saying, hey, maybe we should increase the court from 9 to make it longer, right? To add more justices. That's what one of the arguments about why maybe there should be term limits is because of some of the reasons why this duty to sit and rule of necessity is.
Judge, you got any comment on that?
No, I agree with what Manny said. You know, there's reason people differ on some of the issues as issues have come up before, and then of course one of our the next topic or two, it's going to come up again. So we'll I just think that whether people participating in today's get together feel it's naive of me to say this or not, I just think that, you know, it's so critical to try to, whatever we're going to do, it should be done so we don't further politicize things, both the appearance of it, because that really detracts from not just the independence of the judiciary and the rule of law, but the respect for the system, which that's going to come up again here in a couple of our topics. So
that's a good segue to our next topic, which is on public trust and confidence in the courts. So by way of a little introduction, public trust in the courts is critically important, because when people trust the courts, they are more likely to abide by its decisions, even if they disagree with them. It encourages people to use the courts to resolve disputes by believing they're going to have and receive a fair hearing. And it helps maintain social order by providing a trusted way to address conflicts peacefully. So there are also factors that can erode public trust, and they include perceived bias or unfairness. If people believe that the courts are biased against a certain group, their trust is going to be reduced. When court proceedings are not readily accessible or understandable to the public, it can lead to suspicion and distrust. And of course, public perception of undue political influence on judicial decisions can erode confidence in the judiciary. So, Judge, could you give us some insight into how the federal courts view this issue of public trust and confidence? And are there comments that you would like to make about the recent significant decline in public approval for the federal courts?
well, first of all, I'll say a couple of things that may or may not surprise, whether not unique to this listening group, even though it's a wonderful, the League of Women Voters is a great organization. But when I teach new state or federal judges, a couple of things I say, because this relates, I think, not only to transparency, but confidence, and it relates also to issues of so they can understand your decision, because that relates to bias and the whole politicalization issues. And that is, yes, follow the 3 Ps, preparation, preparation, preparation. But when you're in the courtroom, whether it's the lawyer or their clients or in an organization, people can tell, no matter what their background is, what their race is, what their education is, they can tell if you're listening and caring to what they're saying. And they really can, and that will affect how they view your decision, because then even if they don't agree with your decision, and I'll talk about that in just a moment, then they'll at least they'll believe that, well, he or she listened and seemed to really care, but they because that's a big issue. Next, what's so crucial, I think, to these issues, in the same advice I give to new judges, state or federal, is you have to explain, whether it's orally and or in writing. Just don't say, here's my decision. You have to explain why, how you got from A to B or B to C, or how you made a decision, and explain that so that whether it's the lawyer or the client, they can understand exactly why you made your decision, including, for example, which we'll talk about, I suppose the fancy word sometimes is stare decisis, but separate from that, like I'll say this respectfully, and I'm not unique, I don't believe. I've had a number of cases where I've said my oath is to follow the Constitution, the law, and while I've done that, you shouldn't assume that my decision is fair, because even though the law is constitutional, I was obligated to follow that law. And so I don't believe that was a fair result. And so there's ways you can explain that, because I think to keep the independence of the judiciary, and so that the parties and oftentimes the public, they may not understand what exactly went on in the courtroom, whether they read your decision, especially depending on how if it's a higher profile case and somebody sensationalized it on, but I think it's so crucial. Or say, I can give an example that I suppose Manny would think of, in the criminal context, in some cases where the Congress for many years has said, well, for certain crimes, here's the mandatory minimum that the judge must give regardless of any of these issues, unless you fit an exception. Sometimes I think it's entirely proper for the judge to say, well, I'm required to follow the law, but if it wasn't for that, I would be imposing this sentence. But that's a requirement. You say it in a respectful way, so you're not trying to be critical. But I think explaining everything you're doing, trying to be as transparent and explain that is so crucial, because sometimes I won't single out a case, because this has happened to me both as a state and federal judge. I'll be in some fairly higher profile case, whether it's a trial or a motion hearing to grant the dismissal of the case or not. And then I'll read what comes out in some media forum and say, there must be a case with the same name, because that's not what happened in my courtroom today. And that's not why I decided the case as I did. In fact, many years ago in Virginia, Minnesota, where I was judge in a very high profile case, and he must have trusted me. Otherwise, he probably would have been fired, but I won't name which newspaper it was. And he called me and said, this is what I wrote, but here's what the editor put in. So I'm sorry, because it doesn't really relate. I mean, I'm not saying that happens on a regular basis. This was just a very different type of case. But I mean, and I'm not saying that because there's a lot of great reporters out there too that cover things, and as things now get more accessible to the public too. And but so I think just being transparent and explaining everything that you do and behaving in a way that's respectful to everyone is really the crucial issue. Which is also following your oath of office. And I really think that we all understand that, because we make I mean, it's a great thing, Sue, to wake up, and for the whole audience here, to wake up every morning and go to work and say, my guiding principles are to serve the interests of justice and the public interest. That's nice guiding principles to have. in everything that we do. That doesn't mean we don't have very, very difficult decisions. We do, but that's what we're here for. So I think that's the crucial to perpetuate the rule of law. And so people understand what you did. And like I said, you have to behave that way too. And whether it's how you express yourself in an opinion or how you behave in the courtroom, and lawyers have a name for this. They say, well, he or she doesn't have that ideal judicial temperament, or they do. And so I think that's the crucial thing. So I'm sure Manny's going to maybe have other questions for me, Sue, on that issue. But
You have anything to add to this in terms of the public trust and confidence and kind of the situation we find ourselves in with the culture that we live in, Manny?
Yeah, I do. There was a couple of things that the Judge Frank said that I really want to touch on that are so important. Being transparent. And for me, what that means is when a judge acknowledges my client and sees my client, and it may be something small. Hey, I know you're going through Ramadan and you're fasting right now. Are you feeling okay today? That shows that that the judge that I'm appearing in front of does actually care and knows something about my client. Whether it is, I have a client that for cultural reasons, she can't look the judge in the eye. And instead of saying, look at me when I'm talking to you, because I've had that happen, particularly in state court, but not in federal court, where they recognize that, right? And then just recently, I have a client that's charged with a terrorism case, and he's of Somali descent. And so I had a lot of the Somali community in the courtroom. And the first thing the judge did in that case was say, thank you to all the family members that are here. Thank you all to the friends. And then explained his decision as to why he was going to detain my client, and went through, I appreciate the family's done this, but I've got to look at community safety, this. And when we walked outside, I had 20 community members with me, and not one of them said, that judge doesn't care, or he just is, being racist, this, that. Every one of them said, I love that the judge made eye contact with us. I love the judge recognized all these good things that the client had done, but we get why the judge made the decision. And why was that community happy? Because the judge was transparent, recognized them, looked at everything, and just acknowledged them. And that's what's so important. Nowadays, what I'm getting from clients, am I going over? Sorry, Sue. I just need 30 more seconds. Sorry. Now what I'm seeing, which is really sad, is depending on the case, I will have clients like, don't worry, I'm going to be fine. President Trump is a felon and is in power. So I think I'm going to be okay. I don't need to worry about this case. And so we get some of these political influences that are happening right now, which is not a good thing. Because again, the reality is, at least in our district, the judges are going to look at the case very impartially, and that's the way it should be.
Great. Well, we're going to move on to another aspect of public trust and confidence. So we're talking about judge shopping, Judge. This is an area of some criticism. This happens sometimes where a plaintiff files a case in a district which has just one or two judges, because those judges have a well-known judicial view that the lawyers or the parties believe is sympathetic to their case. So you talked a little bit about the assignment system in Minnesota, and tell us about that as contrasted with this situation where there's just one or two judges, and that's why certain parties file their cases with them. And of course, that's a concern. There's bias in the system. So can you talk a little bit?
Sure. Like, for example, and for people are not aware of this, they may be very surprised, but let's take Minnesota. And that's actually how your local U.S. senators and representatives, and the judges don't decide well, we're going to have one or two or three federal districts in the state. So Minnesota is in a smaller number of states, and actually there are states that are even smaller and larger than us that have even smaller, that have multiple districts, like something Sue DeSalle mentioned before I come to House down here, where why they were passed this way down in especially some of the southern states, where just either one judge in the district or two. In fact, what's called the judicial conference, which we might talk about, is trying to, but there's issues about whether they have the right to do that in terms of, well, let's have more random assignment of more, so they just can't go to one district because they know exactly the judge they're going to get, whatever the reason is they're motivating them to go to that district. But let's take Minnesota with the judges we have. So we have, because so we have 7 federal judges, but really we have more. We have over we have actually 12, because when you take senior status, because then you can stay either full-time like me or go part-time, then there's another person put in your job because you can either leave. So when someone files a case, whether they file at the federal courthouse in Minneapolis, St. Paul, or you could file it in Duluth, it's randomly assigned to one of the 12 of us. In other words, and so you don't know who you're going to get of that group. It's pure random assignment. And as opposed to some districts, well, there's just one judge or two, so you know exactly who you're going to get. So let's try to find a way to file the case. Let's try to find a way to file the case there. So, because the thing is, the other thing, you were going to ask me a question there, Sue?
No, I was just going to say, as I understand it, as a result of the concern over this, this one
Judge shop.
judge district, that there actually a year ago, the judicial
They did.
adopt a new reform in that area. So,
and there's some districts agreeing to it and some saying they have no authority to do that. And so we'll see where it goes. But, and one reason that's so important and why Sue brought it up, we'll see what Manny says too. It's very, very difficult, because a judge or pro se party can file a motion to remove a judge for bias or conflict, whatever words you like. High standard, almost impossible to get a judge removed unless he or she then would say, well, given those facts, I'll recuse. But very difficult to get a judge removed or disqualified. But yeah, because that's been an issue about, well, there's certain groups going to a particular judge because they know exactly who they're going to get. That relates to a couple of the states down in the southern part of the United States. And my understanding is that some of the districts are following that, saying, okay, we're going to have a group now so that you won't know. No, it's not going to be just that judge. And I think no matter what the accusations are, they're concerned it's really affecting what confidence and trust that people have in the system. Well, there must be political other motivations. Why are they going? Because they exactly know why are some of the same groups going to that same place? But Manny, I bet you'll have something you'd like to say about that too.
No, I think you covered it, Judge. I think the concern of judge shopping is a real concern because obviously it's been addressed by the Judicial Council. In criminal cases, we can't do that. I think you see it more in civil cases.
Yeah.
But yeah, I think it's a real concern.
Now, are we short on time, Sue? Can I give, are we?
Yeah, we're getting short on time. So can we move to the next one, Judge? Maybe
Yes.
Give us a few words of explanation about stare decisis, and also known as precedent, and its importance to the legal system.
Well, as part of the oath of office of every federal judge, and actually applies to state judges too, you take an oath to follow precedent. Like for example, for me, precedent would be the 8th Circuit Court of Appeals and the U.S. Supreme Court, because some of the circuits will differ on different things, and up to the U.S. Supreme Court it will go. And you take an oath in fact, especially in civil cases, and it can happen in some criminal cases, depending on what would be called an evidentiary or sentencing issue. But in primarily different types of civil cases, good lawyers will try to convince you during pretrial why their case is factually and legally distinguishable or not distinguishable from precedent called stare decisis. So the judge must follow that, and unless he or she can unless he or she is convinced that our case is legally or factually distinguishable, they must follow that case, or if they don't want to follow it, they'll say why it's legally or factually distinguishable. Well, and so then you have an obligation to do that. I commented on one earlier, you can't be disrespectful to the court, whether it's the US Supreme Court or the Circuit Court, but if I've had a case where I followed, where I have made a different decision and now it's back in front of me, I will sometimes put my conclusion in the case, and I don't think it's too surprising probably to the lawyers saying, well, this is my decision because I'm obligated to follow the law, and I believe it's consistent with following decision made by the Eighth Circuit or the US Supreme Court, because you don't have the option to say, I don't think it's fair, or I don't think it's this, so I'm just going to ignore it. And so that's very, very crucial. And
Right.
and so I suspect we're going to have some questions too about the on whether it's stare decisis or other things. Is social media and other things affecting it? Well, I think it is. That's some of the issues today that didn't exist before, because people have more freedom to say whatever they want to say about the what's going on, you know. And so, but I think that's the crucial issues. About the oath is crystal clear. We must follow it unless we say it's legally or factually distinguishable. And it's a violation of your oath to say, I don't have to follow that precedent. So.
Thank you. Okay, well, Manny, tell us a little bit about the general rule that court hearings documents filed in the court and court decisions are open and available to the public. Could you give us a few examples of when these are not open to the public and why? And how does the public get access to court documents and decisions?
Sure. So generally, courts are always open. Come in, watch a court hearing anytime you want. I've invited my knitting group so they could see like exactly what I do and how courts really are open to the public. What's usually sealed or kept away from the public is usually a couple of instances. One, if there's a victim. So if there's a victim of an assault or a sexual assault, and you want to respect that victim's privacy. You don't want it to be that victims don't feel like they can file or cooperate in a criminal prosecution or even a civil prosecution, but then be named and feel shame that may come with it, which shouldn't be, but that happens. If it's a minor, so usually in federal courts, we use initials, but sometimes it's easy to identify the minor, especially if it's a parent or a grandparent that's a part of a civil suit or named in a criminal case. So we want to keep that document where it names the minor, even by initials, sealed. The other times it's if the defendant, my client, has been cooperating, and let's say they're cooperating against other entities, whether it's his boss at work or if it's her cartel people, for safety reasons, right? Because we don't want that person that's trying to do the right thing by cooperating, then all of a sudden their name is exposed or published in newspapers that they've cooperated with the United States, to then all of a sudden be killed or harm come to their families. And then if it's that I write to the judge about my client's medical needs, and you know, HIPAA says we can't disclose that, right? So it shouldn't be made public. So a lot of times you'll see on a criminal docket, the sealed documents. It's usually to protect the victim. If there's cooperation, protect a minor. Those are usually the most categories that I see. Everything else, it's available to the public, whether you come into the courtroom or you go on the docket and pull up a document. And for a small fee, you can pull whatever document you want to see and you can print it out and have a copy of it. So all the documents are available. I will say this just to kind of wrap this section up. A lot of judges now are asking me to file a redacted document. So if I do a section where I talk about my client's medical issues, they will say, take that out or black it out, and then submit the position pleading. A position pleading is where I'm taking a stand on what I think the judge should do at sentencing. Take that part out that's private redact it and file it so it's a public document. And so I have been doing that a lot more, as where I think the courts are trying to get the public's trust back, saying let's not file so many things under seal so the public has access to it.
So
And
I
I just, oh, go ahead, sorry.
was just going to mention that for everyone to know that everything is digital now in the courts. Everything is filed electronically, and all of the accessibility is electronic as well. So this is why it's important that if there are matters that should be confidential, that's why they're redacted. But other than that, they're all open for and accessible to the public.
And just in 1 minute or less, because I know we're at I think the other thing I'll say that relates to the digital is that even though there's reasonable people that differ, not on the public thing, but some people are having more and more, the federal courts not having more and more Zoom hearings, and nobody has to come to court. But one of the true advantages, what I call it, access to justice. If we have a victim in a crime or a plaintiff or defendant, whether it's because they're scared to come to court or they have a disability, we can arrange to have them Zoom in and watch the whole thing. In other words, saying, well, they can't get here, they can't do this, they're scared, but they don't have the ability. We can set that up. And so that's an access to justice issue that we can have, whether it's a client or it's a victim or someone with a disability or somebody else that's scared to come to court or can't come. That's happening a lot more too, because we've got the technology because of the pandemic that we've capped the people. We can have them come in and they can Zoom in and watch.
Great. Well, we want to go to the questions from our participants here. We're going to go to the questions for participants, and I'm going to call on Deb Price, Lake Minnetonka Plymouth area member who's been monitoring that Q&A box, and turning it over to you. Good morning.
Good morning. Thank you, audience, for all your good questions. I think most of them were answered by the panelists, but I will just call out a couple of ones. The final slide will have the QR code for you to scan, which will take you to all the resources, and our webinar should be available in a few days. One of the questions that was asked was about the software assignments that select the judges. And is this throughout the nation? And what happens if there's only one judge per district in that district?
Well, one, it's throughout the nation, but something that Sue DeSalle touched on, and because the judicial conference under the thing of judge shopping, then there is no random assignment in that software if there's just a one judge court. And so that's why this is what's called the judicial conference, which is that involves the chief judge of each circuit court, the chief judge of the U.S. Supreme Court, and a chief judge of each district. They've tried to come up with a plan to put a group of judges from that region of the country. So there's a random assignment to try to reduce the judge shopping if they feel, especially if they feel it's being done for other political or other reasons. But that's because it really that's the key in those small districts, and there isn't much to the random assignment. I don't know if Manny or Sue want to say anything about that too.
That's good.
Thank you. If you could clarify, are the complaints about the judges or the justices and the results public information?
My response to that is it depends upon the nature of the complaint, and one, whether a motion's been filed, whether I know that sometimes there's complaints maybe about how you treat. I've been reading about some things. We haven't had any here in our district, knock on wood, on how you treat staff and so forth. But some of those are public, some of them are not. And Manny, you touched on that too, I think, depending upon the nature. And then depending on who decides it, sometimes there's a public reprimand, sometimes it's a private reprimand, depending upon the issue. And I know that some people think it's more of it should be public. Manny, you might have something to say about that, or Sue?
Yeah, I think it just varies. If the lawyer files something, then it's going to be
Yeah.
public. If it is like, if I went to Judge Frank and said, this just happened in court with a different judge, of course, there's not going to be anything public about that. But so I think it just varies.
Okay, thank you. Another question, would a future proposed change such as 18-year term limits for the Supreme Court justices or cameras in the courtrooms promote or diminish judicial independence, transparency, accountability, or ethical conduct?
Manny, would you like to talk about the 18-year issue? 'Cause
Yeah,
I know
it was-
reasonable people differ. Some things that say that would make it more political, some less. Some say it'd be less independence, but I'll turn it over to Manny.
So I think it can be good or bad. I was thinking about this when I was
Right.
thinking about the duty to sit. So, one of the negative things about the 18-year term limit is they're saying it's a lack of stability because there's going to be turnover. Right now, the process is kind of slow. Like we went through from 94 to 2005 without a single new justice, and that any changes could be a little too radical. But on the positive side, maybe we want justices that are more in step with what's going on, right? And by that I mean, do we want a justice that's, 95 years old and doesn't know about all the new emerging things that are happening to us in our everyday lives? Like, do we want somebody more in step with what's going on and what's happening with everyday Americans? And then it's also giving more people, more presidents, the opportunity to be able to appoint somebody, right? So if you have 18-year term limits, it's more likely a sitting president could appoint somebody versus not being able to appoint somebody. So I can see the pros and the cons. And I'm not sure where I personally stand on it. But yeah, I can see the pros and the cons for the term limits.
And cameras in the courts?
Well, they're coming much more in the state court than the federal court, and that's an issue being discussed. Just because there's some because there's both pros and cons to it. The pro is, of course, the increased public access. The concern, I think, is like, for example, even is especially for jury trials and so forth, protecting the public and or not the public, the people inside the courtroom, but that's an issue being discussed because they're getting more and more public in the state court, and I think probably Manny has probably a more. Be curious to see what your opinion is on that.
So my view is I don't like it because I think it's already scary enough for my client to be in federal court, and a lot of times there's no family members, then all of a sudden their face is up there. And let's say they're found not guilty. Let's say they're not convicted, and now forever they're going to be a pariah. Like, well, you were the one that were charged, and people recognize their faces, particularly when you're in a small community like on the Red Lake Indian Reservation. On the other hand, like when the Chauvin trial was happening, I thought that was so great that the judge allowed cameras in the courtroom. Why? Because a lot of times there's a perception that perhaps because it's police officers, the prosecutor's going to throw the case because they don't really want these law enforcement officers to be convicted. So we're going to throw the case. And if it had been a not guilty verdict, I was afraid that was what was going to happen. But because it was cameras in the courtroom and people every day were following and seeing that the prosecutor was doing their jobs, seeing that every witness that got up there and said XYZ, no matter how it went, nobody could say that nobody did their job correctly. And I think the only reason that was because there was cameras in the courtroom. I also do think, like, sometimes I know that if I'm trying to get a witness to come into court and testify on behalf of my client, and it's not a very popular client, maybe they're accused of something bad, and it's an employer or a family member, that I will say, God, there's not gonna be cameras in the courtroom, because I'll get up there and tell the truth. But if there's cameras in the courtroom, I'm not gonna get up there because I don't want people in my community to say that I vouched for this guy. And it may be simply as, hey, I need you to establish an alibi. He was at work that day, but they don't want to be looked at that they helped somebody that was charged with a crime. So I'm not a big fan of it, but in the Chauvin trial, I think it was the right thing to do.
And that issue is being discussed at all
Yeah.
over the country for the federal court. And the other thing is that indirectly relates to that, like for a higher profile case where there are no cameras, we don't turn the public away. We'll zoom it into other courtrooms, or so in other words, so we'll say, okay, we'll zoom it here, zoom it there in the building so that anybody who's taking the time to come here. But yeah, it's an issue being discussed because, like I say, reasonable people differ, and I think there's more and more discussion about, well, there ought to be we're being criticized because there should be some more increased public access and cameras. So that's an issue that's being discussed, but I think Manny kind of covered both the pros and cons of that in terms of what's the best next steps. So
I have a question for the two of you, which relates to these proposals for change. This is the purpose. The league is putting together a position on the federal courts. And one of the things that the National Committee has come up with is some overarching principles that they believe we should consider when we're looking at these proposals for change to how the federal courts might be structured or how they operate. And these are the ones that we were just talking about in terms of judicial independence, transparency, accountability, and ethical conduct. So we're just, some couple of words or thoughts. Do you feel that considering proposals for change like we just described as examples, are these principles seem to be valid ones that we should consider? How does a particular proposal affect, harm, or promote judicial independence and the like? And were there any others that we should be thinking about that we look through the lens of a principle when thinking about a change to the federal judiciary? So, Manny, start with you.
You want to start, Manny?
Oh, go ahead.
Yeah, I do think everything that we've discussed today goes towards the fairness, the public trust, the integrity of the court. So I think they're all really important principles. One thing for me, and this is probably not something the league can comment on necessarily, but or there can be principles put in place. It's something that Judge Frank and I have talked about frequently is the news media and the climate right now. It's so quick to say this is an Obama appointee, this is a Biden appointee, this is a Trump appointee. And now because they ruled this way, we should impeach or we should get this judge off. That is completely taking away from judicial independence. That is completely taking away from impartiality. And it's just going to be stopped. We cannot do that. I mean, it's hard for people that are not in the system to really see that it doesn't, when I go in front of a judge, it doesn't matter to me if they're a Trump appointee or Obama appointee, Clinton appointee, we have a Bush appointee. It doesn't matter because I know that judge is going to be fair and impartial. And even if that judge rules against me, you're never going to hear me say, oh, that's because he was appointed by a conservative president. Oh, that's because he was appointed by a Democrat. Doesn't happen. So that's one of the issues that I think, I don't know what we do about it, but it has to be stopped.
Okay, Judge, I'm sorry, but we've run out of time. And
Well, that's okay.
thank you very much. I just want to
Well, I'd like to thank the League of Women Voters too for all that you do. And like I said
Yes.
at the beginning, I've met a number of league folks just because of all the great work you do, especially to naturalizations here in our district. So it's always been a privilege. So.
Well, back to the two of you, Judge Frank and Manny, thank you so much for giving us such very helpful window into the federal courts and important foundational information for our members as we participate in this National Federal Judiciary Study process. So members and guests, let me also thank all of you who participated this morning in this webinar. And members, please watch for the date of your local league's consensus meeting. And finally, special thanks go to Mary Broad of LWV Minnesota for her invaluable technical support. Everyone, thank you.
Can I say one other thing?
Sure.
The St. Paul Courthouse now for almost a year has had what's called the Justice and Democracy Center open to the public on floor 1. And we've already invited 1,500 different students and groups in this year, and they usually they try to meet with at least one judge. So anytime the league would like to come in, then we have a public outreach worker. We can make that happen. I'm always willing to give the Better Homes and Gardens tour in my chambers and courtroom too. So, but yeah, we truly have that, and they're building one now in the federal courthouse in Minneapolis too, to give the public more access to learn more about the federal court.
Wonderful. Thank you for that gracious offer. Thank you for being with us today. And so everyone who participated and attended this, thank you and have a good day.